Hello, my name is Joseph Canner, and I'm a second-year law student here at the Michigan State University College of Law. And more importantly than that, I'm a lifelong sports fan. I'm going to be talking to you about the ongoing fight for student-athlete compensation. This fight has taken many forms, and in the wake of the NCAA v. Alston decision, in which the Supreme Court, the highest court in the land, unanimously decided that the NCAA's bylaws limiting the education-related benefits schools could offer student-athletes violated the Sherman Act. Alston is important for a variety of reasons, not least of which because it virtually invited further legal challenges to the NCAA's restrictive policies on athletes' compensation. The NCAA is now facing 3 such challenges. Those legal battles are ongoing. I'm going to break down the Alston case for you, then touch on those upcoming legal challenges, and make a recommendation on how the courts, the National Labor Relations Board, and Congress should proceed with the business of college sport.
To understand this case, I need to explain a little bit about antitrust law. Antitrust law is essentially competition law. It's a series of statutes that protect consumers and producers within the free market. The 2 main issues in antitrust are monopolies and restraints on trade. Anytime you are setting the price and not allowing the free market to set the price for consumers, think antitrust implications. Alright, so the federal government deals with claims pertaining to mostly 3 antitrust statutes: the Sherman Antitrust Act, the Clayton Act, and the Federal Trade Commission Act. And just like the statutes, there are 3 frameworks for analysis courts use to decide antitrust cases: the per se rule, then we've got the rule of reason, and the quick look analysis. The rule of reason is the default courts use in antitrust cases, and they've actually emphasized several times it is the proper framework for evaluating NCAA cases. The rule of reason is a 3-step analysis that relies on a burden-shifting framework. First, the plaintiff bears the initial burden of establishing not only the relevant market or markets affected, but the restraint in question and how the restraint causes them injury. Another way to say this is the anti-competitive effects of the restraint. If the plaintiff meets this initial burden, the burden then shifts to the defendant, who must come forward with the pro-competitive effects of the restraint. In this case, the NCAA is saying, we have this rule for XYZ reason, and it is essential to our goals of effectuating XYZ. If the defendant meets this burden, the burden shifts back to the plaintiffs, and they need to prove the defendant could effectuate their goals through less restrictive purposes. If we've gotten all the way to the end, the court must decide if the alternatives proposed by the plaintiff are less restrictive while still effectuating the goals of the defendant. The court in Alston took the time to dive into the history of college sports because it's particularly relevant to the arguments raised by the NCAA. But I've been told we're on a time crunch here, and there's a lot to discuss. So what you really need to know is throughout the history of college athletics, athletes have always been paid. In the early days, the 1800s through 1905, there were virtually no rules except the rules the teams played by themselves. We are going to be focusing on football because the business of sports is really the business of football. Football accounts for 70% or more of every college athletic department's revenue. We only have time to show a few examples, but look up your favorite public institution's athletic department information, and you will see this is true across the board. In the early days, the desire to win was so fierce, athletes who had no affiliation with the academic institution were playing for teams. Indeed, teams would pay so-called tramp athletes to come into town to play for their team to win a particular game, and then the player would leave, being heartily compensated. Perhaps the most famous example of this is Michigan's legendary coach Fielding Yost, a West Virginia native who was attending West Virginia Law School and playing for the Mountaineers football team. The Mountaineers lost to the Leopards of Lafayette, who had an upcoming matchup against their rival, Penn. The Leopards paid Yost to transfer to the school, which he did. Yost led the Leopards to a 6-4 win over their rival Penn, then transferred back to West Virginia the next week. This was known as the Yost Affair, and while the most famous example of this so-called tramp athlete phenomenon, this was all too common. There are thousands of examples of this happening. The phenomenon of the tramp athlete, as well as numerous severe injuries and fatalities, finally sparked reform. In 1906, 60 schools came together in New York to adopt new rules on safety and player compensation. The Intercollegiate Athletic Association, or IAA, was formed that year. It established that all athletes competing in college sports or amateurs must be protected as such, and any athlete who receives compensation for athletic performance or attendance at a certain school forfeits their amateur status and would be unable to participate in college sport. This is important because right away we have a textbook definition of a horizontal restraint on trade. Institutions coming together to decide on rules regarding how they will compete with each other. Because these amateur rules state students can't receive any compensation, they are fixing the market price for these recruits at zero. When we know the free market would allow these schools to increase compensation to get the best available players and win. So you have seen the market and the restraint, but Joe, is this even a commercial enterprise? Well, let's get into it. The NCAA is a nonprofit. It's a nonprofit that generates $1.1 billion of revenue every year. About 70 to 80% of that comes from the March Madness tournament. Because guess what? The NCAA doesn't run football. The college football playoff does. So the most lucrative sport among all college sports isn't even included in this revenue, and they still make $1.1 billion a year. The president makes $4 million a year. Remember, I said football is not included. And remember, I said football is also the most lucrative sport by far. So let's look at that entity, the College Football Playoff, or CFP Administration LLC. They make roughly $600 million a year, and that's set to go up to $2 billion when the new television contract kicks in. That's television rights, merchandise, ticket sales, and the like. Just like the NCAA, it distributes a lot of this money to conferences based on performance. For every team your conference has make the college football playoff, semifinal games that is, you get $6 million. For a non-playoff New Year's Six game, you get $4 million. And other non-New Year's Six bowl games have payouts as well. They're just a little bit smaller. So the Big Ten is a good example because they distribute revenue equally among their conference participants. So last year, both Michigan and Ohio State made the college football playoff, and Penn State also made a New Year's Six game. That means only factoring in New Year's Six payouts, because they sent other teams to bowl games as well, the college football playoff paid the Big Ten $16 million. That's more than any other conference. Because the Big Ten distributes that revenue evenly, that means every Big Ten school got $1.14 million and change, again, not factoring in other bowl games' regular payouts. It's fair to say these organizations are commercial enterprises. What about the school athletic departments themselves? Well, to be a commercial enterprise, you have to make money. And how do we determine if you make money? We look at your revenue generated and then balance it with your costs. If we do that, you'd actually only find 18 to 22 school athletic departments that make money depending on the year. Yet, if you look at the highest paid public employee in every state, you routinely see coaches at the top. In this data, completed in 2017, you see 40 states had football or basketball coaches as their highest paid public employee. 16 states actually had the top 3 public employees as a football or basketball coach or athletic director. In 2 states, Washington and Louisiana, not only had the top 3 highest paid employees being coaches, but those 2 states had a coach who wasn't even coaching anymore. That's right, Washington and Louisiana had a coach fired, they paid them a contract buyout to leave and not coach there anymore, and they were still amongst the highest paid public employees in the state for that year. So the question is, if these schools don't make money, why are you investing so heavily in sports? Well, the answer is short and sweet. They're lying. The books are cooked. Like I said, we look at revenue and cost, but it's quite easy to make a profitable business look unprofitable if you do some creative accounting. It's called transfer price accounting. Athletic departments' costs include scholarships, full grants and aid to athletes, but they don't actually write a check to the university for that. That cost is calculated and taken out of their budget, but the actual price is nickels or dimes on the dollar to what they're actually charging. Because giving a scholarship to an athlete often doesn't mean they're actually taking another tuition-paying student's place at the university. If they were, then the cost would make sense because it's not just the amount to house and feed that student, but also the opportunity cost of losing another student that would otherwise be paying tuition going there. But In almost every instance, that's not the case. So that's one way in which there are reporting costs that are actually higher than they truly are. Then we have the issue of what the schools are doing. Athletic departments are subsidized by booster donations. Now ask yourself, is it easier to ask for money when it looks like you don't have any? Yes. There is no incentive for universities to appear profitable because it makes it easier to ask for donations and makes it easier to appear to not be a commercial enterprise if it looks like you don't make money. Again, we're looking at the revenues and the costs. So if you make $30 million, all you have to do to appear not profitable is raise your cost, $30 million. In college athletics, that's easily done. Salaries for coaches, not just head coaches, but assistant coaches, other staff, as well as, let's say, a big construction project on athletic facilities that maybe aren't really necessary, or a renovation that's not really necessary, and which research shows doesn't actually affect recruiting in a meaningful way, boom, that $30 million profit has disappeared, all in the name of investing in a program without investing in the athlete. Lastly, they make money in ways that aren't attributed to sports but are directly trackable. This is called the Flutie effect. Doug Flutie was an undersized quarterback at Boston College, and after his famous Hail Mary to cement an upset victory on national TV, Boston College saw a significant uptick in applications to the school. And that's just one instance. There are hundreds more. Look at Butler and their national championship runs, Florida Gulf Coast and VCU in the March Madness tournament. Sports teams perform well. When they do, it's free marketing, especially for previously unknown universities with less name recognition. This is why universities invest so heavily in sports, because it all pays dividends. So I hope by now I've been able to demonstrate the market, the restraint, and the fact that we are dealing with commercial enterprises. Now we just need to evaluate the pro and anti-competitive effects. The district court in Alston had no trouble in finding the restraint had significant anti-competitive effects. The burden shifted to the defendant, who made a bevy of arguments, all of which the court found unpersuasive. The NCAA argued that their restraints served pro-competitive purposes of increasing output, maintaining competitive balance, and preserving amateurism, which differentiated college sports from pro sports, offering the consumer a unique choice. All of these arguments were rejected in the 9-0 decision. I was shocked to learn that the Alston decision of the court was actually delivered by Justice Neil Gorsuch, because the most famous decision in this case was a blistering, blustery concurrence from Justice Brett Kavanaugh, in which he criticized the NCAA's unfair business model and invited further legal challenges. The three pending legal challenges we will now discuss in turn. Grant House v. NCAA is a case that once again pertains to NIL. It's another antitrust class action where student athletes are challenging the NCAA rules regarding athletes' ability to ask for a share of the broadcasting revenue enjoyed by the conferences. Johnson v. NCAA is involving a group of FCS or lower division college football players suing the NCAA for violation of antitrust law and violation of several states' minimum wage laws. They're asking to be considered hourly employees in the same way graduate students are. The case has survived a motion to dismiss by the NCAA in the Pennsylvania District Court and should see an initial decision this year. The last case is a matter being looked at by the NLRB, or the National Labor Relations Board, which oversees employee rights at private companies as it pertains to their ability to organize and collectively bargain. This is not the first time the NLRB has handled a matter of college football. The Northwestern football players brought a case back in the 2010s to organize and collectively bargain with the university. We actually had a very interesting symposium on it here at MSU. The claim was based on the common law definition of an employee, and I think it's easy to see how the college football players fit into this. They signed to play with a particular school, they performed services for the university, giving them a crazy amount of hours per week, often way more than the time they're doing academic activities, and the school and team exerts a crazy amount of control over them. They dictate where they live, what they can eat, how often they eat, what their weekend consists of, film study, travel to and from games, practice times, team meetings, etc. It's a fascinating case and a great read. I encourage you to check out the trial transcripts, including the testimony of quarterback Kane Coulter, who is the face of the case, and the testimony of head coach Pat Fitzgerald. But to summarize, the regional director of the NLRB found for the plaintiffs and granted them the right to organize. However, Northwestern appealed, and on appeal, the NLRB panel did not decide the issue of whether these athletes should be deemed employees, but instead as is their right, declined jurisdiction over the matter because of the large ramifications their decision to let them organize would have on college sports as a whole. So what's changed between then and now? Why do we have this issue back before the NLRB? Well, there's been a changing of the guard. General Counsel for the NLRB, Jennifer Abruzzo, issued a memo in which she said she feels student athletes have been misclassified and should be employees and given the right to unionize. Once this memo began circulating, a challenge quickly followed, and the current claim before the NLRB comes from Pac-12 players against USC, the Pac-12, and the NCAA for unfair labor practices under the Fair Labor Standards Act and the right to organize. If Abruzzo's position is shared by her colleagues at the NLRB, student athletes could very well earn employee status.
If they are deemed employees, they can organize, and they can collectively bargain for great things like workers' comp and health insurance. That's a great thing. You're right, it is. But they would earn the right to do just that, bargain. And when you are collectively bargaining, everything is on the table. That scholarship is negotiable. Your NIL rights, that's negotiable. Health insurance and the like, that's negotiable. This would be one of the youngest unions, not in the country, but the whole world. And more than that, it's a union in which your members are continuously turning over at least every 4 years, if not sooner. Plus, you have a variety of varying interests. How are you going to come to a consensus on what to bargain for? Is the star quarterback at Georgia's interests the same as the star quarterback at Memphis? What about the backup quarterback at Georgia? What about the star gymnast at Texas A&M? What about the backup left tackle at Notre Dame? You have to reconcile all these interests and come together to bargain when there's already inherently unequal bargaining power between the university and the athletes. If you're in a non-revenue generating sport, it's harder to collectively bargain because while you may be putting in the same amount of work, time, and effort as the football players, you're not generating the same output. Then you have to consider Title IX. If athletics form a union, you don't think schools are going to take measures to save their bottom line? This could mean cutting a lot of non-revenue sports. This is why I believe unionizing is not what's best for the student athletes, because despite what they could gain, they need to think about what they could lose. I leave you with this. My opinion is that Congress should not bail out the NCAA. They should continue to make their bylaws subject to antitrust rules, and they should codify only exceptions to the employee rule as it pertains to organizing and collective bargaining. College sports is currently the wild, wild west. And from an athlete's perspective, it has never been better. Change is likely coming, and we should all keep a close eye on what that change might be.